Once a, yes, please start.
Good evening, sir, and to all the participants present here. I am Neet Kaur, volunteer of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Jaydeep Mehta, sir, and to all the participants in this 2 weeks online national capacity building program on art of contract drafting from fundamental to enforcement, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about drafting of various important clauses in contract. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is a privilege to have with us and honor to introduce Jaydeep Mehta, sir, Independent Director and Advocate, High Court of Bombay and Gujarat. Sir is a qualified lawyer from University of Mumbai, a qualified independent director certified by Indian Institute of Corporate Affairs, and a dynamic professional with extensive experience of nearly 34 years in legal and secretarial, corporate, and general affairs, having expertise in the areas of corporate legislations, drafting contracts and agreements, and legal compliance. Sir has done graduation in commerce from Bharatiya Vidya Bhavan's University of Mumbai and is a law graduate from prestigious KC Law College, University of Mumbai. Sir has also completed LLM. Sir is NISM certified professional. Sir started his professional career in 1989 as a management trainee in legal department with Atul Limited. Before entering into legal profession, Sir worked with one of Kirloskar Group of companies and handled its legal and secretarial affairs, and also worked in capital market and was instrumental in handling many IPOs as a registrar to the issue. Sir possesses wide experience in security law, corporate law, FAMA, and other commercial laws. Sir demonstrated excellence in handling the telecom BPO project of Bharti Airtel and Videocon Telecom independently during his previous employment. Sir is a founder and partner of Lake Street Advisors LLP, advocates and solicitors of a full service law firm. His law firm Lake Street now also acts as an advisor to insolvency professionals. His law firm Lake Street has also started GST litigation and advisory practices in Mumbai and Gujarat region. We are deeply honored to have you with us today, sir. Over to you, sir.
My screen is visible?
Yes, sir.
Yes, yes.
Okay. Good evening, all of you, and thank you, Sambhav, for taking this initiative and inviting me to this and giving me this opportunity to present uh, a topic, a very important topic, art of contract drafting from fundamentals to enforcement. So let me. So what I have done is I am trying to break up all various topics. So starting with introduction to contract drafting, fundamentals of a valid contract, key elements of effective drafting, common clauses, which are the common clauses in contracts, then drafting techniques for clarity and precision, pitfalls to avoid in contract drafting, and then another important subject is enforcement of contracts. What are the legal and practical insights? We will also try to cover case studies, though there are very few case studies as far as Indian contract law is concerned, but there are some landmark judgments of Honorable Supreme Court and also by various foreign courts. So that's how we are trying to break up on various different topics. So let us start with contracts. So exactly, so before that, let me tell, I would like to tell that I am told that there are various, many are very senior practicing advocates also here. I can see Dr. Kalpesh Gupta sir, who is here. He is a very, talented researcher here. So if there are any, if I make any mistakes, please correct me because there are more talented people who are in the room today. So let me start with our main topic today, what is contract. So what exactly is contract? As we all are aware that in today's complex business environment, nothing can progress without without drafting and execution of a valid contract. And now let me tell you that in the olden days when there was a Rama, and we all are aware that there was a proverb that Raghukul Niti Sada Chali Ai Pran Jaya Par Vachan Na Jaye. So Vachan, in those days, Vachan was a very valuable, but those days of Ramayana and Mahabharata are gone now. Today, even in the the present circumstances, even the well drafted and executed contracts are not followed, and that is the reason why we see disputes going keep on increasing in today's complex business environment. And the latest being, and a very well known being, and many of you must have read that judgment of Tata and Mr. Mistry. So that complications arose out of contract only. But we will talk later on. But it's basically contracts. What I am trying to convey is that contracts form the backbone of modern legal and business systems that ensures predictability and enforceability. So we will come to that. What is predictability and what is enforceability between the parties? Whether it is a property related agreements or it's a purchase of materials, whether it is a lease, rent, etc., are basically the legal framework that safeguards the rights and obligations between the parties. So, as all of you are aware, and many of your students, and many of you are students and maybe practicing lawyers or CA and CS, all of you are aware that the basic contract which govern the contracts is Indian Contract Act 1872. So this legislation basically it constitutes a valid and enforceable contracts, and there are various guidelines, various legal provisions which are prescribed under the Indian Contract Act, which are required to be followed very strictly while drafting a contract. So let me now come to what is this. In the previous slide, I talked about predictability and enforceability. So what exactly is predictability in as far as the Indian Contract Act is concerned? So if you can read on the screen, predictability in contract law refers to the extent to which the parties can reasonably anticipate the legal consequences of their contractual agreements and actions. This predictability is very crucial for both the parties which are entering into a contract and for legal professionals for advising them as it follows for as it allows for informed decision making and risk assessment. So if we talk about what exactly is what is the importance of predictability? So the first one is informed. It helps in informed decision making for the parties as well as for the professionals who has been given the task of drafting the contract. So informed decision making in the sense that it helps the parties to understand the potential outcome of their contractual choices. So the second one is risk management. So by knowing the potential liabilities and remedies, parties can better manage the risk associated with a contract. So now this basically applies more practical to large contracts. For normal contracts day to day, which normally we see, it may not be of much importance, but large contracts which are being entered into between the corporates, one corporate and the other corporate, or maybe in joint venture agreements, or maybe in shareholders agreement, share subscription agreement, this type of high profile contracts, these is factors are very important. So it helps in decision making, it helps in assessing the risk which is likely to arise in future. And so that's what about predictability. So let me come now to the contract. What are the statutory provisions? Now, originally, if all of you have studied the Indian Contract Act, and maybe some of you are still studying, some of you are practicing. So originally there were 266 sections, and later on, uh, the two main provisions which are related to the sale of goods and partnership were deleted. So initially, when this statute was formed way back in 1872, and let me also inform you that it came into force on 1st September 1872. You can see how old this contract is. So this particular statute is one of the oldest Indian statute which was brought into force much before the India we attained independence. So it's a very old statute, and there were sections related to sale of goods act which were earlier, which contained in section 76 to 123, which was those sections were deleted, repealed, and later on the special act, Sale of Goods Act 1932, was incorporated, and those provisions were later on transferred to Sale of Goods Act. And similarly, there were provisions for partnership under the Indian Contract Act in earlier when the statute was brought into force. That was in section 239 to 266. So later on, these provisions related to partnership were converted into a Special Partnership Act 1932, which perhaps all of you are very well aware. Now, main concept under the Indian Contract Act. So, in the day-to-day, in our day-to-day professional life, we keep on talking about contract and agreement, contracts and agreement. So, basically, what is the definition of contract, and what is the definition of agreement? So, before we come to the drafting and enforcement, we need to understand the basic concepts of drafting a contract. And there are certain basic definitions which we need to understand and analyze. So what the Indian Contract Act talks about contract. So section 2H, if you read section 2 clause H of the Indian Contract Act 1872, it states that an agreement enforceable by law is a contract. So it looks very simple definition. So contract means an agreement enforceable by law. So that takes us to another question. Then what is the agreement? And what is what is the agreement, and which are the agreements which are enforceable by law? So that is what we will talk about in the subsequent slides. So agreement is defined in section 2E. So let me read section 2E. So what it states, agreement. If you have Contract Act with you can refer. But section 2E, it says that every promise and every set of promises forming the consideration for each other is an agreement. So this takes us to one important aspect of contract, that it is a promise or set of promises and forming consideration. So consideration is an important part of a contract. So, and as all of you are aware, section 10 defines, and all of you have studied also, what it states, that section 10 clarifies that of the Indian Contract Act states that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So this definition gives us certain basic elements of a contract. So that takes us to main key elements of a contract. So what it indicates basically, a contract under the Indian Contract Act 1872 requires an agreement. What is that? What exactly is an agreement? So it is an offer plus acceptance plus consideration. So this definition takes us to three basic elements of an effective contract: offer plus acceptance and consideration. So we will talk in detail in subsequent slides. Another aspect is lawful consideration, means something of which consists of value which is exchanged between the two contracting parties. Third is a lawful object. The purpose of the contract must be legal. It cannot be illegal, or object cannot be unlawful. That also we are going to discuss later on. The fourth aspect is competent parties. That is, the parties which are executing the contract are competent to enter into a contract. So in simple terms, let me explain in a basic terms. For example, so there is a very famous case law which all of you are aware, Mohir Bibi versus Dharamdas Ghosh, which talks about the minority capacity of the party who is a minor. So this very well-known case, it states that a minor is not competent to enter into contract. So competent parties who are capable of entering into a contract. For another example, let me tell you, in case of a company, because company is an artificial person, it cannot sign. So company has to authorize somebody, some responsible officer to sign the contract. So whether that person who is signing on behalf of the company, whether he has been given a proper authority to sign that particular contract, and that authority will certainly differ from contract to contract. So whether the company has given an authority to that particular officer to sign up that one particular contract. So that is another example of competency of parties. Another aspect is free consent. So agreement, what is free consent? That we will come to that later on. And these are some of the main basic ingredients of a valid contract. So now that after understanding the basic elements of of a contract for drafting of Indian or a contract under the Indian Contract Act, now let us come to the today's topic. What exactly is contract drafting, and what is the importance of contract drafting, and what is the role of professionals like advocates, chartered accountants, and company secretaries? So basically, contract drafting, in day-to-day life, we all are using this drafting of a contract, and contract agreement. But what exactly it is? What is the drafting of contract? So if we talk about legal definition, so though there is no legal definition of contract drafting, basically it is a process of creating a legally binding agreement. Please understand this language. The process of creating a legally binding agreement that clearly establishes the rights, obligations, and remedies of the parties involved in accordance with the applicable laws. Let me repeat once again because it is very important. What is contract drafting? It establishes the legal relationships between the contracting parties. Further, it establishes the rights of the contracting parties. What are the rights of the parties who are executing the contract? what are the obligations, and what are the remedies. Remedies means when the contract is breached by any of the contracting parties, what are the remedies available to the contracting parties. That is where we will discuss about the enforcement of the contract. So basically, a contract drafting is the process of creating a legally binding agreement which establishes the rights of the parties, obligations of the contracting parties, and remedies available to the parties in accordance with the applicable law. Now we will come to know applicable law. Of course, Indian Contract Act is the central act as far as the contract drafting is concerned. But there are when we talk about contract drafting, it depends on the subject matter of the contract drafting. So if it is related to say drafting of sale deed, if it is related to drafting of say joint venture agreement, if it is related to share subscription agreement, share purchase agreement, there are different subjects which are involved. So accordingly, apart from the Indian Contract Act, other applicable act will also be applicable. That is why it is I have mentioned here that in accordance with applicable laws. So what is the importance of contract drafting? Why it is so important? So basically, the first one is it prevents disputes. If the contract is drafted very properly, professionally, it will prevent dispute in future. There is a less chance of that disputes are likely to arise in future. It protects the interest of both the parties to the contract. So well drafted contracts include remedies for breach of contract, for example, liquidated damages, or in case of termination. So what that particular what we, it protects the rights of the contracting parties. And third one, it facilitates enforcement. So when in if any of the if the situation arises when any of one of the parties to the contract breaches the terms of the contract, in such situation, the affected party can easily enforce the contract. So these are the main important points, importance of contract drafting. So what is the role of CS advocates? You all are aware that advocates is basically is deemed to have expertise in drafting the contracts. Now, when we talk about other professionals, like say chartered accountants or company secretaries, CS, when a particular clause arises where there is where the parties are affected as far as the financial terms are concerned. Like say if the agreement involves taxation part, or it adversely affects the financial implications on the parties, in such situations, of course the professional can take the help of CS also, because every advocate may not be expert in taxation laws or may not be expert in financial transactions. So where the contracts involves financially, it affects the adversely affects the parties as far as the financial transactions are concerned, or there is an implication of the taxation. It can be in direct, indirect taxes. In such situations, chartered accountants may have an edge over uh, advocates who have been given the task of drafting. CS, if we talk about CS, they are basically more expertise over, as far as the compliance is concerned. So maybe compliance under the say Companies Act, or maybe other acts, maybe under say SEBI Act, if the SEBI is involved, SEBI Act is involved in. So basically, what I'm trying to convey to all the participants is every professional has their independent role. Advocates has its own role in drafting contracts. CS also have their independent role, and similarly, CS also has their independent role. So every professional has his or her own role in drafting the contracts. So basically, when any assignment is given uh, to any professional, so my advice would be to take into confidence even the other professionals for say taxation or compliance part. So now let us come to the essential elements of a contract. So basically, I have tried to break up fundamentals of a valid contract. So the first is what are the basic essential elements of a contract, though we have discussed earlier, but here I will try to cover in a detailed provisions. Types of contracts, there are express contract, implied contract, what is bilateral contract, what is unilateral contract. We will try to cover maximum what is possible. So let us now cover what are the essential elements of a valid contract. So starting with, as we discussed in earlier slides, offer and acceptance. This is the first basic element of a valid contract. So every contract starts with a valid offer made by one party and its unconditional acceptance by the other party. That means offer. If we take the practical example of any, say, employment contract. So any professional or anyone who is given an offer by any employer. So what that is called an offer. That is an offer. And if all of you are aware that when the prospective employee is given a copy of that offer letter, he is expected to read each and every clause of the employment letter. So a company has given an offer letter, an employee who is willing to get an employment with that particular company, it is his duty to read each and every clause of the employment letter. And if he is happy with uh, each and every clause, he is supposed to give his unconditional acceptance. So the first requirement, the basic element of a valid contract is offer by one party and its unqualified and unconditional acceptance by the other party. So the terms of the offer should be clear, definite, and communicated to the offeree. So this is one basic example. Another basic element is there, there has to be an intention between both the parties to the contract to create legal relationship. For an agreement, for any agreement to convert it into a valid contract, the parties need to intend to create legal obligations. Social or domestic agreements usually do not have that intention, whereas the business agreements usually have a legal obligations. So there, the first is offer and acceptance. Second basic element is an intention to create legal relationship. That is second one. Third one, which I discussed earlier in section 2D, when section 2H, when we discussed about the definition of agreement in section 2H. So what it stated, an agreement, not section, about consideration, section 2D. So what it states, section 2D, the consideration, there has to be a lawful consideration, offer, acceptance, intention to create legal relationship, but there has to be an element of consideration. Consideration includes the valuation between the parties, including money. It can be monetary, it can be rendering of services and or a promise. So lawful consideration. So what section 2D we discussed earlier, when at the desire of the promisor, the promisee or any other person, let me read section 2D, what it states. When at the desire of the promisor, that is a person who is giving an offer, the promisee or any other has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So offer, acceptance, legal relationship and consideration, the agreement, the contract, the element of lawful consideration must be present. So that is the third, lawful consideration. So let me give an example for consideration. In consideration of erecting and say any building, a contractor agrees to receive rupees to X amount in care by check or cash. So the money paid and the service of construction involved are proper consideration. So there has to be a lawful consideration. So that is a third important element of a very contract. The fourth is capacity of the parties. The provisions are contained in section 11:12. So we have to consider the legal provisions. Please understand very carefully that all these elements for drafting a valid contract are given under the Indian Contract Act 1872. So let us discuss about capacity of the parties. The provisions are very clearly stated in section 11. What section 11 states? Let us read section 11 of the Indian Contract Act. The heading of the section 11 is who are competent to contract. So what it states, every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So the capacity of the parties is the fourth basic element. The fifth one is free consent. Again, there are provisions for free consent which are specifically covered under section 13 to 19. So just basic we will discuss because we have to also deliberate on the contract drafting and enforceability. So free consent, the provisions are very categorically stated under section 13 to 19 of the Indian Contract Act. So if we talk about consent, what it states, section 13, the two or more persons are said to consent when they agree upon the same thing in the same sense. Section 14 talks about free consent. So consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake subject to the provision of section 20, 21, 22. So free consent means it is not by coercion. So we will not discuss much in detail about coercion, undue influence, fraud, misrepresentation, mistake. These are the 5 exceptions. If these 5 are not present, then consent is said to be free. Consent is said to be free when there is no coercion, there is no undue influence, there is no fraud, misrepresentation, and mistake. These are the 5 exceptions, but these are again a very topic which are very we can discuss in depth. We can have even a separate session only on this particular section itself. So we will not deliberate in detail about coercion, undue influence, fraud, misrepresentation, which are covered in section 15, 16, 17, 18. And also read section 21, 20, 21, 22. So the fifth basic element is the consent of the contracting party should be free. The sixth one is lawful object. Again, it is covered. There is a separate provision under section 23. Please understand that for every basic element of a valid contract are covered under the specifically covered under the Indian Contract Act. So if I read section 23, which talks about lawful object, what it states, the consideration or object of an agreement is lawful unless it is forbidden by law or if is of such a nature that if permitted it would defeat the provisions of any law or is fraudulent or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Again, it is a very deep subject. So the section 23 talks about lawful object. The object of the contract must be lawful and not against public policy, or it should not be illegal. So very simple example, let me give you. If the two contracting parties, if the two persons are entering into a contract of smuggling goods, can it be considered as lawful object? No, certainly not, because smuggling goods is not a lawful object. Or maybe say two persons are entering into a contract that we will share the profits out of the say dabba trading. Dabba trading means illegal transactions in shares outside the BSC, NSC, or stock exchanges. So the object of the contract must be lawful, which is covered under the Indian Contract Act. There cannot be an agreement or contract for any unlawful object. So that is another sixth one. Seventh one is certainty and clarity. Again, there is a provision under section 29. So what it's section 29 talks about certainty and clarity of contract. The terms of the contract must be clear and not vague or ambiguous. A contract a contract with uncertain terms is can be considered as void. Illustration, let me give you. An agreement to deliver a reasonable quantity of any food grain is vague. So when you draft a contract for supplying any particular goods, there has to be a specific quantity, specific quality. Just if you draft simple terms, if you write that an agreement to deliver a reasonable quantity or particular quality of any food grain to the other party, it is a vague contract. So the section 29 is very clear that the terms of the contract must be clear and not vague. The eighth one, there are 10 basic elements of a valid contract. Let us talk about the eighth one, that is the possibility of performance. And that provisions are specifically given in section 56 of the Indian Contract Act. The contract should have obligations that are capable of being performed. Contracts which require the performance of acts impossible to perform are void. So the contract must be of such a nature that it is capable of performing. So that is the eighth one. The ninth element of a valid contract is compliance with legal formalities. There are some contracts which are governed by specific legal formalities. They may be required to be in writing, signed, registered, or attested. So there are certain contracts which are governed by special acts or special provisions under uh, uh, another act. For example, if I give you a practical example, so any transaction related to, say, immovable property, for example, sale of a residential flat or any commercial property, so that are compulsorily required to be in writing, which is required to be registered, which all of you may be aware that the property transaction, especially property related to uh, immovable properties, which are compulsorily required to be registered before the sub-registry authority, and that provisions are separately covered under the Registration Act 1908. So that is a ninth provision. And tenth provision, agreement not expressly declared void. A valid contract, those provisions are again given under section 24 up to section 30 of the Contract Act. A valid contract shall not fall within agreements which are expressed by the Indian Contract Act is declared to be void. So there are certain provisions which are under the for the contracts which are declared void, and those provisions are specifically covered under section 24 up to section 30 of the Indian Contract Act. So these are the 10 basic elements which are required to be taken care of while drafting a contract. So 10, so we can say that these are the mandatory elements of a valid and effective contract. We discussed this fundamentals of a valid contract. So while drafting a valid contract, so let us again recapitulate, discuss again. So number one, intention to enter into a legal relationship. Second is offer, then acceptance. Third is promiser, the person who is giving the offer. Promisee, the person to whom the offer is given. Then lawful consideration, section 2D we discussed. Capacities of the parties, free consent, lawful object, certainty and clarity, possibility of performance, agreements not expressly declared void. So these are the main basic elements which must be present in every contract, irrespective of the subject matter. Now, let me come to the topic of express contract and implied contract. So there are certain contracts which are express and there are certain contracts which can be implied. So basic definition, though it is given here, let us just deliberate on a couple of difference. We need not discuss the each and every one. But what is the difference between express contract and implied contract? A contract formed through explicit and clear terms, whether verbal or written, that is express contract. Now, implied contract, let me give you a practical example what can be termed as implied contract, which normally we all everyone experience in our day-to-day life. Implied contract, for example, say a very practical example, when we go to the say any say restaurant for a fine dining with our family, so there we are not entering into any contract. When we go with friends or family to any restaurants and we sit on the table and we go through the menu of the hotel, what are the foods available, and then we order to the hotel, to the waiter. And there we agree that we are ordering to a hotel based on the menu. And it is implied because we agree to pay the price for price to the hotel, right? So this is implied contract. Another example we can say that in our day-to-day life we experience, we normally whenever require we hire a cab, a taxi or auto. There we are not entering to any contract. So when we hire a taxi, we agree that we are willing to pay the price. You must be hiring a say Ola or Uber or maybe an auto. There we agree to pay the price because we are taking the services of the service provider. So these are some of the examples of implied contract. So another difference of express contract, the terms of the contract are communicated directly either in writing or verbally. In case of express contract, the terms of the contract are not explicitly communicated, like the example which we discussed. So these are some of the difference between express contract and implied contract. Implied contract may not be always in writing, like the example we discussed about entering in, taking the services of a restaurant or a cab. So I will be sharing this PPT with Sambhav, so you can go through the details. There are what are the difference between express contract and implied contract. So there are certain key elements of effective drafting. So let me discuss that also. Okay. So what are the other key elements of effective drafting? So one is clarity. Another is completeness. Third one is consistency, compliance, and customization. So what is that? Clarity, as we have already discussed earlier. Completeness. So what is completeness? Let me explain you what is the completeness. So address all the scenarios. So the subject for which you are drafting the contract, you are in a better position to visualize what could be the situation. So you need to address all the scenarios, including the contingencies which are likely to arise in future for that particular contract. See, contract drafting is a very, very, very deep subject. And let me tell you, it is not everybody's cup of tea to draft a fine contract. It only the professionals can draft. So when you are sitting to draft any particular contract, completeness is a very important element. Now, let me give you a concrete example of, say, if you are drafting a contract for, say, with a contractor or a builder. So you know the person, you know your client, and you know what are the situations which can arise in future, including any contingencies. So as a professional, you are in a better position to visualize that particular situation which are likely to arise. So completeness is one thing. Another is consistency. So use uniform terms. For now, if I explain you what is consistency in a contract. For example, if you are drafting a contract related to, say, a sale deed. A sale deed means a sale deed relating to properties, immovable properties. For example, you are drafting a contract for a sale of a particular commercial property. Now, what is happening in such when you draft a contract, it happens that you are using a different terminologies. For example, now when I talk about consistency means at one place for you are using sometimes the person who is drafting a contract, you are using at one place you are using the term buyer, at some other place you are using the term purchaser. So that should not happen. So consistency means either you use the same term, either you use the terminology buyer at every place, or you use the terminology purchaser at every place. Just to explain you in a very simple language. So do not use different terminologies for the same you can say situation. So do not use buyer as well as purchaser. At one place you are using the terminology buyer, at another place you are using some purchaser, and then again you are using buyer, at some third place again you are using purchaser. Do not do that. Maintain consistency. Use only one terminology. The third one is compliance. Compliance is again very important. You have to comply the applicable laws. So align with laws like the Companies Act or the GST or the SEBI regulations or any other applicable law. And fifth one is customization. Customization means stick to a particular, when you are drafting for a particular subject matter, please customize your template accordingly. Do not use any unnecessarily jargons. So that is the importance of effective drafting, and which are required to be maintained uniformly. Clarity, completeness, consistency, compliance, and customization. Now, let me come to the another important aspect. So, which are the common clauses in a contract, which I would like to discuss, and with a practical example also, I would like to deliberate. So, I will be also highlighting agreement for template of an agreement so that you will understand. So, which are the main common clauses in a contract which are required to be followed systematically? So, first one is preamble. So, what is preamble? I will explain you when I on the screen I will display agreement. So, preamble basically it is the title of the agreement. So, preamble, recitals, that is another second one. Third one is definition clause. Fourth one is obligations of parties. Fifth one is payment terms, payment clause, termination clause, dispute resolution mechanism clause, force majeure clause, confidentiality clause. Uh, Please understand all these clauses which are very important and which are, you can say, common clauses, but which are in the form of a mandatory nature. We can say that these are the clauses which are mandatory. So if we talk about checklist of clauses to be included in a contract, we can arrange in this sequence. Title of the agreement, names of the parties, recitals, definitions, representations and warranties, covenants, uh, terms of the contract, consideration of the contract, terms of payment or mode of payment, indemnification, that is indemnity clause, termination clause, invoices, force majeure, intellectual property in case intellectual property rights are also involved. Confidentiality, basically it is confidentiality is normally it is in every transaction. Exclusivity, severability, Severability also I will explain. Amendment in a contract clause. These are the clauses. Jurisdiction, which are the governing laws, dispute resolution mechanism, signatures of the parties, schedules and annexures in certain cases where schedules are required to be attached. For example, in case of properties, when there are multiple properties, and particularly you need to mention in schedules and annexer the exact details of the properties involved, survey numbers, including particular survey numbers, sub-survey numbers, city survey numbers, house number. So these everything need to be covered in detail. So it is advisable to cover mention all these details in a separate schedules which are attached to the main agreement. Entire agreement is again a different concept which I will inform you. Duplicate copies of the agreement. So now let us understand the drafting techniques for clarity and precision. So why it is important? Because it helps the contracting parties to understand the terms of the contract easily. So normally I advise everyone that use plain language. Do not resort to cut, copy, paste. As we all are aware that ample of materials are nowadays available on Google. Now we have AI with us. So all subjects, all the templates are available, but never use the method of cut, copy, and paste blindly. You can, of course, everybody is using, but it is to be used systematically. So use plain language, avoid archaic terms like whereas. Sometimes at multiple places, if you see any contract, you will observe that there are at multiple places the words terms like whereas, henceforth, etc. are used. So example also I have given. For example, say party A will pay instead of party A shall henceforth remit. So it is to be, the language is must be plain. Structure it logically. Use headings, subheadings, and number each and every clause wherever required in the main clause. If the sub clauses are required at appropriate place, use separate number for sub clauses. For example, if the main clause is at number 4 and there are sub clauses under that clause, so please number it separately. For example, 4, main clause is 4, then use either 4.A or 4.1, then 4.2 or 4.B, 4.3, 4.C, whatever is convenient to you. Avoid ambiguity. So incorporate schedules and annexures that in the previous slide I informed. Review and revise. This is a very important. So when you draft a contract and say first draft is ready, and both the parties, there can be multiple parties, not both the parties, there can be multiple parties, even if there are 10 parties to the agreement, give a copy of the first draft to each and every party. Let every party review it. Let every party give their suggestions. Consider their suggestions uh, religiously. If it is acceptable, include it. If it is not acceptable, do not consider. So review and revise. That there can be first draft, second draft, third draft. So before the final draft, there can be 5 or 6 times a review or revision. So let it be. But review and revision of a contract is of prime importance. These are some of the pitfalls to avoid in contract drafting. Avoid vague terms. avoid complex languages. It confuses the parties. Ignoring jurisdiction. So if there are cross-border countries are there, different countries are there, then jurisdiction is very important. Neglecting of risk allocation, that is another separate topic. So non-compliance. So basically, these are some of the mistakes which normally professionals are making. So I will come to the practical aspects when we discuss a template of the agreement. So now let us come to the, so before that, let me explain that various clauses which I will try to put on the screen. Let me open it. So this is on the screen right now.
No, sir, only PPT is visible.
PPT is visible, 1 minute. So I would like to upload one sample agreement which I would like to display on the screen. So can someone help me? So that we can discuss all the clauses.
Sir, let me.
1 minute, 1 minute.
second.
So
I'm just
stop
stopping
sharing,
your.
stop sharing it. 1 minute, yes.
Yeah, I stopped seeing it.
So now let me share that agreement. Okay, is it visible now?
Yes, sir.
Is
Yes.
it visible now?
Yes, sir. Yes.
So it is a loan agreement. So let us go through this loan agreement. So we started with preamble to the agreement. So normally every agreement starts with this kind of words. If it is a loan agreement, it starts with this kind of words. This loan agreement, and into bracket hereinafter referred to as the agreement. So in subsequent clauses, we need not repeat loan agreement. For example, if it is a say joint venture agreement or a share purchase agreement or a building construction agreement, into bracket write that hereinafter referred to as the agreement, so that every time you need not repeat loan agreement, share purchase agreement or building construction agreement. So this loan agreement, agreement basically starts with these words. This loan agreement hereinafter referred to as the agreement, bracket over, is made and entered into on so and so day. For example, say today's date is 4th August 2025. Now, also here I have not mentioned, but it is very important to mention the place. This loan agreement is made and entered on the 4th day of August 2025 at, say, if it is in New Delhi, mention New Delhi. Between name of the bank, since it is a loan agreement, you have to mention the name of the bank. So let us consider it is a State Bank of India. So between a State Bank of India, a body corporate constituted under the Banking Company so and so Act 1970, having its head office at so and so place, hereinafter referred to as the lender, because it is a loan agreement, which expression shall, unless repugnant to the context or meaning thereof, be deemed to mean and include its successors and assigns. So normally it starts with these words because it is a bank. So even if it is an individual, these words will always be there, because if it is not there, their legal heirs will uh, continue, can continue. And second party here is a borrower. It can be a company, it can be an individual borrower or an LLP or a private limited or a limited company. So details of the borrower will be covered here. name of the borrower. In case of he or she is an individual, then it will be son oblique daughter of so and so, aged so and so, residing at so and holding qualification of so and so, hereinafter referred to as the borrower. So here also I have mentioned, so that in future, if the borrower is not in existence, in case of future, at some future date, if disputes arise between the bank and the borrower, the bank can also involve the legal heirs. That is why these words are very important. It includes legal heirs, executors, administrators, and legal representatives. So normally, I also advise that also please mention, in case of bank, say bank's PAN number, under earlier here, like State Bank of India, or if it is a limited company, mention its registered office address. Here it is a bank, so it is a head office address. In case of borrower, it is advisable also mention his PAN number or Aadhaar card number, present address and permanent address. If it is both the addresses are different, please do not forget to mention present address as well as permanent address. Now, here we mention the details. The borrower, whereas the borrower is a professional and has requested the lender for a loan for professional purposes, and the lender has, after due consideration, agreed to sanction the loan subject to the terms and conditions hereafter appearing. So it starts with the basic terms, that the borrower has approached the bank, and bank, after due consideration, has agreed to sanction the loan, and the borrower has agreed to avail the loan on the terms and conditions set forth in this agreement. Now, the another clause which we discussed earlier, definition clause and interpretation clause. It can be only definition clause. Interpretation, if you want to use it, well and good. So what this clause includes? So this is in this particular case, because it is a loan agreement related to loan. So it starts with the definition of agreement. What is agreement? What is loan? Loan means the principal amount of so and so. What is interest rate? What will be the tenure? So what is tenure? What is EMI? So this definition clause will differ from each agreement. It will be different for building construction agreement. It will be different for the various terms used in share purchase agreement. It will be different in some other agreement. So definition clause the terms which are required to be covered in the definition clause will differ from contract to contract. So this is just a template which I am displaying. So in case of loan agreement, it is interest rate, tenure, EMI, due date, then event of default, security, what will be the applicable law, sanction of the loan. So subject to the terms and conditions of this agreement, the lender agrees to lend to the borrower a sum of rupees so and so. It will be stated in words and figures very categorically, very specifically. Ensure that the amount in words and figure tally. So these kind of mistakes are likely to happen when you resort to cut, copy, and paste. So you are free to use. I am not saying that do not use AI or Google. Everyone is using. I am also using. But you can only borrow an ideas from Google templates or AI templates. So you have to fit that particular template as per the situation prevailing for your particular case. So if you do blindly copy similar, for example, if you are drafting a building construction agreement and you have borrowed that agreement from someone else, maybe your friend or relatives, and you are blindly copying, 100% chances are there you are going to make a blunder mistake. You are free to use the template. I am also aware, and you are also aware that n number of templates are available, readily available in Google and now on AI platforms. But you cannot blindly use it. You can only borrow an idea, but apply your brain. Do not apply the brain of AI. Use your own brain when you draft a contract for your client or for your purpose. So, sanction of the loan in this particular case. Third, clause interest and charges, because it is a loan agreement. The borrower shall pay interest on the principal amount of the loan at the interest rate of so and so. Here it is specified. See, you can see as specified in Schedule 1. The interest shall be calculated on so and so reducing balance method. The lender shall have the right to revise the interest rate. So lender, it is a loan agreement. So bank is keeping the right to revise the interest rate. So this agreement is particularly very risky, not risky, but you can say in case of say various NBFCs are now giving loans, you must be receiving phone calls every day from various NBFCs and banks that you are eligible to get a loan on your four-wheeler, you are eligible to get a loan, personal loan, and they are using this kind of agreement, which if you are borrowing, you must read each and every clause, sub-clause thoroughly, or you can even show it to a professional. So these are the standard terms for loan agreement. Interest and charges clause. The fourth clause here is a repayment clause. How the lender, how the borrower will repay. So this clause pertains to repayment. The borrower shall repay the loan along with interest in so and so EMI as per the repayment schedule. Again, it is as stated in Schedule 1. The borrower shall pay the EMI on or after the due date or before the due date of each month. So these are the repayment terms, clause related to repayment terms. Any delay, you can see the 4.3, any delay in payment of the EMI shall attract a penal interest at the rate specified in Schedule 1. So the bank has very clearly in detail stated everything in Schedule 1. What will be the EMI? What will be the rate of interest? What will be the delayed interest on delayed payment? Everything will be in Schedule 1. So that is related to the fifth clause in this agreement is security. The loan, bank will give you a loan only on security, as all of you are aware. So what is the security? That detail is given here. The loan shall be secured by what? Description of the security, which is again given in Schedule 2. Whether you are taking loan by mortgaging your house or your factory premises, if it's a business loan. So it is a security clause. The borrower hereby covenants. Covenants means the terms and conditions which the borrower, the contracting parties are agreeing. The borrower hereby covenants, that means agree with the lender that he or she shall punctually pay all EMIs and other dues on the due dates. Now here the dispute starts arising. You are agreeing. I hope everyone understand English. Anyone has, at the beginning, I forgot to ask a question, whether Hindi is preferred or English is preferred. English is okay with
English,
everyone, all
yes, English is
participants?
okay, sir. Yes, just
Okay.
participants from different background, states.
So what happens when you are blindly signing the agreement, when the borrower is blindly signing the agreement, because he is getting the money from the bank. So whatever bank tells, he is blindly signing and he is agreeing. All these clauses, punctually pay, I will pay all the EMI on the due date. The borrower shall not utilize the loan for any purpose other than for which it has been sanctioned. The borrower shall provide all information and documents. The borrower shall keep the lender informed of any change in his or her address. These are the clauses in the standard clause in the loan agreement. And the dispute will arise when the borrower starts defaulting in repayment. That is what is happening with various companies, which you all are reading in various print medias, electronic medias. When companies are defaulting, what happens when companies are defaulting? Then the legal dispute starts. Representation and warranty clause. The borrower represents and warrants to the lender that, let us read it, he or she has the legal capacity and authority to enter into this agreement. Here comes the clause, competency of parties. All information and documents provided by him to the lender are true, accurate, and complete. So you are agreeing, you are not giving any illegal documents or bogus documents. You are agreeing, the next clause, there are no legal proceedings, claims, or disputes pending against you, against him or her that may affect his ability to repay the loan. So everything, all the bank is taking from the borrower, all these undertaking in the form of a legally executed agreements. So these are the mandatory clauses in the agreement. Events of default. Now here is a clause. What happens if there is a default? The occurrence of any of the following events shall constitute an event of default. What happens if you fail when the borrower fails to repay? Failure to pay an EMI or other dues, breach of any of the covenants, representations, or warranties made by the borrower under this agreement, the borrower becoming insolvent, bankrupt, or making the death or permanent incapacitation of the borrower. What happens if the borrower becomes permanent disability? Here comes the role of legal representatives. The security is found to be inadequate. The loan is. So these are the clauses for event of default. See the heading of this. Events of default. These are the clauses which will be considered as default by the banker. What are the consequences of default? Upon the occurrence of any of the event of default, the lender shall have the right to demand immediate repayment of the entire outstanding loan amount. Enforce the security. अगर आपने अपना घर mortgage में रख दिया है, the bank has the right to enforce that security. That is where we are talking about enforcement of the contract. This is one of the clause for the bank for enforcement of security. Indemnity. The borrower agrees to indemnify and keep the lender indemnified against any loss, damages, cost, expenses incurred by the lender on account of any default or so. जब आप लोन लेता है कोई कंपनी और मे बी इंडिविजुअल, बैंक आपके हथकंडे काट लेगा, आपके कंडे आपको हम जो बोलते हैं ना, the bank is giving you money, and against that the bank is taking all the rights from the borrower in case the borrower defaults in repayment. This is a notice clause. All notices, demands, other communication under this agreement shall be in writing and shall be deemed to have been duly given if delivered personally, sent by registered post. So this is a clause in every, this clause is will be there in every contract, irrespective of any subject matter. We can say this. I don't know whether the participants have heard about boilerplate clauses. So these are, you can say, a boilerplate clause means which are the clauses which are mandatory in every contract. Notice clause, where the notices are sent at the address given by you in the agreement. आपने आगे देखा है, आपने कमिटमेंट भी किया है कि अगर मेरा एड्रेस चेंज हो जाएगा तो आई विल इन्फॉर्म द बैंक. So at notice clause, what are the governing law and jurisdiction? This agreement shall be governed by and construed in accordance with the laws of India. This is the governing law and jurisdiction. The courts at so and so city. So if the agreement, if the banks, if the agreement is executed in say Mumbai city, then the courts at Mumbai city shall have exclusive jurisdiction to entertain any suit, proceeding or dispute arising out of this agreement. अगर दिल्ली में execute हुआ है, then the jurisdiction, the courts at Delhi will be the jurisdiction. So the place of execution of agreement is very important, and not only the place where the parties are residing, that can also be the court for jurisdiction. So in case if the bank, the branch at you can say located in Pune city is giving you a loan, then the courts at Pune in Maharashtra shall have exclusive jurisdiction. Arbitration clause. This is the clause, very important clause regarding dispute resolution mechanism. In case the disputes arises, what will be the mechanism? So this is again a mandatory clause. Any dispute, let us read this clause. Any dispute or difference arising between the parties concerning the interpretation or implementation of this agreement. So it states that if any dispute or difference arises between the parties to this agreement, shall be referred to arbitration in accordance with the provisions of the Arbitration and Conciliation Act 1996. So here again, let me tell you, if it is a contracting parties involves any say a private limited company or a limited company or maybe banks or institutions, then there can be a provision, and now normally under the present circumstances they prefer institutional arbitration. So in that case you have to very categorically state here that the disputing parties, that the affecting parties shall have a right to appoint an institutional dispute. Let me reframe it. Any dispute or difference arising between the parties shall be referred to any institutional arbitration to be decided by the parties, or maybe affecting party will have the right to appoint institutional arbitration in accordance with the provisions of the Arbitration and Conciliation Act. Now, all of you now may be aware, since you all are professionals, nowadays there are many institutional arbitration which are providing the services as an institution which facilitate arbitration. For example, Nani Palkhiwala Arbitration Center, Delhi Arbitration Center, Hyderabad International Arbitration Center, Mumbai International Arbitration Center is there. So these are some of the arbitration centers which are considered as institutional arbitration. So you can also mention the specific name of the specific arbiter institution. So what I am trying to convey that whatever you want as a contracting parties, the specific wordings must be included so that there is no confusing in future. Entire agreement. So let me explain this. This is also mandatory clause that this agreement along with its schedules and annexures constitutes the entire agreement between the parties and supersedes all prior discussions, negotiations, and agreements, whether oral or written. So, if there is any other discussions which have taken place between the contracting parties, or there are any other prior written agreements are there, it will supersede everything, and this agreement will only be considered as an entire agreement. अगर कोई डिस्प्यूट अराइज हुआ एंड सब्सिक्वेंटली कोई पार्टी ऐसा बोलते हैं नहीं हमने तो जो पहले एग्रीमेंट किया था उसमें ऐसा था, नो, दैट एग्रीमेंट विल नॉट बी कंसिडर्ड. This agreement is the final agreement and this is considered as the entire agreement. Another clause is severability clause. What is the importance of this clause? If any provision of this agreement is held to be invalid or unenforceable, the remaining provisions shall continue in full force and effect. The classic example, let me give you, is relating to arbitration clause. There are various Supreme Court judgments, very landmark judgments, which have categorically stated that even if the entire agreement is void ab initio, even if the entire agreement is void, arbitration agreement will sustain. So just for your information I am sharing. So now these are the clauses at the end. In witness whereof the parties have executed this agreement on the date first above written. So schedule 1, loan details. Schedule 2, details of the security. Witnesses, name of the witnesses, signature of the witnesses, name of the witnesses, addresses of the witnesses. Further, I will go further. PAN card, not PAN card, but you can say even PAN card is also okay. PAN card number of the witnesses, that is also considered. Aadhaar card number of the witnesses, along with a copy of the these documents are also required to be attached. For the lender, who is signing for the lender, name of the authorized signatory, name, designation of the authorized signatory, ensure that the proper resolution is attached, that particular authority officer is authorized. So there will be, if it is a company, there will be board resolution. If it is a bank, there will be authority letter issued by the higher authority, and who signing signature of the borrower. So these are the purpose of this template is to make you understand that these are the clauses which are required. So some of the clauses are mandatory. Now operative clauses means in case of bank agreement, in case of loan agreement of the bank, we have gone through the clauses, but some of the clauses will differ depending upon the nature of the transaction. In case of building construction, some of the clauses will change. In case of share purchase agreement, some of the clauses will change, and you will have to give the effect of some of the important provisions of the Companies Act or the SEBI Act or the SEBI rules and regulations accordingly. So it differs. Clauses, operative clauses differ from contract to contract. Let me now come to the main. Do we have time? Because I hope we can
So it's
continue.
8:30, sir. So
Or if you have question answer, we can take up question answer also.
yes, sir. Participant, any question query from your side? So Prashant Sharma, we'll take a couple of questions because already 8:30. So
Okay,
Prashant Sharma,
okay,
over to
fine,
you.
fine, fine.
Yes, sir.
Okay, I'm okay.
Prashant
Good
Sharma, over
evening,
to you.
sir.
Yes, sir.
Good
I
evening,
will
sir.
try
Thank
to
you for
answer.
the
I will try
wonderful
to
lecture.
answer. Or even if any of the participants or learned participants are here, they can also
Yes, yes.
participate.
Prashant, over to you. Prashant.
Yes, sir. Yes, Prashant Sharma. So what I will do, I will also share the entire material. Enforceability, I wanted to deliberate, but we have, time is passing. So
Yes,
I will.
Prashant Sharma, over to you.
Yes,
Hello, sir.
Prashant Sharma.
Good evening, sir.
Good evening.
Thank you for this wonderful lecture. Sir, I wanted to ask you in the entire agreement clause, you have mentioned that the schedule and annexure. Do we need to also mention the amendment and annexure that is to be made after the agreement? Or
Amendment.
the amendment and annexure that we used to make after executing the main agreement, or we have to make another clause for amendment?
Okay, no. So once the say agreement is finally executed, and subsequently, if there is an amendment, so that is also a very important question. Good question. So you can include one clause related to amendment clause, that in case uh, the situation arises where the agreement is required to be amended, or any clause of the agreement is required to be amended, then the party shall execute a separate agreement. We can say amendment or supplementary agreement. So you can execute a separate supplementary agreement. So if it is not a very lengthy one, then you can execute another agreement superseding the earlier agreement, whereby wherein you can consider the amendments which you are going to propose or you have proposed. So either you can execute a supplementary agreement, or if it is not necessary, that only if you want to make a particular change in a particular say clause only, which is not very lengthy, then you can amend the main agreement, and then you can also state that the earlier agreement executed on so and so date between so and so party is may please be shall be considered as repealed, and this revised agreement shall be considered. So that can also be done.
So, sir, supplementary agreement is the entire agreement that we have revised in entirety. Like the prior or the principal agreement shall cease to exist once the supplementary agreement
Yes.
came into force. Is that
But,
correct?
okay, can you repeat, please? Let me understand.
I am just wanted to understand the difference between supplementary agreement and amendments or addendums.
Oh, see,
So,
supplementary agreement you are executing for only for amendment which you want to propose or you have proposed. Supplementary agreement is only related to the amended clauses, amendments.
so amendment is the supplementary agreement, right?
Yes, yes, yes,
Okay, okay.
yes.
And one more thing, sir. Sir, in the party details, we have mentioned that the so and so party is herein referred to as borrower lender, and that again there is one long clause that herein with referred to as express as so and so here and there, their hairs can and so on. So
Right.
can we make something easy for that particular clause? Because it is quite technical, and you said use plain
Yeah,
language
see,
and
the technical is there because it is always be there when you draft a legal agreement. So the purpose of this particular terminology is to ensure to the contracting parties that in case the contracting parties is not in existence, or for example, let me take this particular case for it is executed by X, and subsequently if some other bank has taken over now, as you are aware, a lot of banks are taken over by Bank of Baroda and SBI. So if that
yeah, the
situation
merger of
at the time
banks.
of merger, then this clause will be applicable.
Okay. And sir, one more thing, you talked about sanction letter and board resolution. Can you please explain it again?
Board
Authority letter.
resolution means suppose if it is uh, any
Company.
company, private
Yeah.
limited company or a limited company registered
Limited
under the
companies.
Companies Act.
Yep.
And company is an artificial person, company cannot sign.
Yes.
So company has to authorize any of its senior officer to sign the agreement.
Yeah.
There you have to ensure that that particular officer has either the authority letter from the director or a managing director, or there is a board resolution authorizing a particular concerned officer to sign the agreement.
Sir, who is this officer who is signing at the
See,
place of borrower?
pardon, can you repeat?
And who is this officer who is signing in the place of borrower in the agreement? Right?
No, no,
Like you
borrower,
said, na, no, you said the officer who has the authority from the company or the bank must have the authority letter. So
correct.
the officer you were talking about is the person who will sign at the place of the borrower in the agreement.
If the borrower is a company,
If a borrower is a company, yes,
yes, if borrower is an individual, then of
then
course
it is no authority letter
there is no
required.
authority is not required. But there that clause will also be applicable. In case the individual borrower is not in future, it is not in existence, or if he is dead, then his legal
Heirs,
representatives,
yes,
so
yes.
that the bank can recover from the legal representatives. That is why this clause is mandatory for in every contract, irrespective of subject matter.
Okay. So in the portion where borrower signs, the same thing happen in that case also, right?
Yes,
Like the
yes,
officer must have the authority from the bank to
yes,
sign.
yes, yes,
Oh,
yes, yes, yes,
okay.
yes.
Thank you, sir. That's all.
Welcome,
Thank you.
welcome.
Yes, sir, we can, sir, close the session. It's already 2:38. Sorry, 8:38. So thank you very much, Jaydeep sir, for your insightful
Welcome, sir.
session.
Thank you, thank
And
you.
then you again, very importantly, you discuss the contract, real contract, how it looks like, along
So
with the
before,
theory.
before, if participants, I would like to tell that contract drafting is a very specialized subject, and it is not as a cannot discuss into say 1 or 2 hours session. It's a very deep subject. And if just I wanted to ensure inform. So our partner has written 2 books. If any of this is one book, Drafting Commercial Contracts, Practical Guide to Drafting Commercial Contracts, written by Mr. Bhumesh Verma. He is our partner. And he has also written another book, same author, Contract Drafting Tips and Tricks. So I would suggest every participant to uh, buy this book, not a very expensive book. So if you read these 2 books, I can assure you, you will be an expert in contract drafting.
Yes. I'm connected to Bhunesh sir, so he keeps sharing
Ah,
update, and I know about this book also.
yes,
Thank you.
yes, yes. He is our partner rather.
Yes, sir. So thank you very much, sir. I look forward to seeing you in future events. Thank you.
Thank you. Thank you
Thank
all
you,
the
sir.
participants for patient hearing.
Thank you.
And thank you, Sambhav, for giving this opportunity once again. Thank you so much.
Thank
Thank
you,
you,
sir. Thank
sir.
you, sir.
Thank
Thank you,
you.
sir.
So can I log off?
Yes.
Yeah. Thank you.